Before we begin, please note that the information provided in this video is for educational purposes only and does not constitute legal advice. The content of this presentation is not intended to create, and receipt of it does not constitute, an attorney-client relationship. You should not act or refrain from acting on the basis of any information in this video without seeking appropriate legal or other professional advice on the particular facts and circumstances at issue from an attorney licensed in your state. Imagine this. You're driving home, thinking about dinner, and the light ahead turns green. You ease into the intersection, and then out of the corner of your eye a flash of red, a sickening crunch of metal. Your world spins. When everything stops, your car is a wreck, your head is pounding, and a sharp searing pain is shooting up your spine. The other driver ran a red light. It was 100% their fault. The next 48 hours are a blur of police reports, tow trucks, and a trip to the emergency room. You're in pain. You can't work. The medical bills are already starting to pile up. Then your phone rings. It's a friendly, sympathetic voice from the other driver's insurance company. They say they're so sorry for what happened. They say they want to make things right quickly so you can put this all behind you. They offer you $10,000 cash. All you have to do is sign a few simple forms. In that moment, with the stress and the pain and the financial pressure mounting, that $10,000 feels like a lifeline, feels like a solution. But taking that check, saying yes to that friendly voice on the phone, could be the single most financially devastating mistake of your entire life. What that adjuster doesn't tell you is that the back injury you think is just a sprain might actually be a herniated disc that will require surgery in 6 months. They don't tell you that $10,000 won't even cover the deductible for that surgery, let alone the lost wages from being out of work for another 2 months. They don't tell you that the paper you're signing isn't just a receipt for the cash. It's a release form, a legal document that forever signs away your right to get another single penny from them, no matter how bad your injuries turn out to be. They know this. They have teams of lawyers, armies of adjusters, and decades of data on exactly how to get injured people to accept the lowest possible offer. They are professionals at minimizing their own financial exposure. And in that moment, what do you have? You have pain, confusion, and a mountain of stress. It is not a fair fight. It's a lion negotiating with a lamb. Now, most people in this situation realize pretty quickly that they need help. They know they need a lawyer. So what do? They do what they've been conditioned to do. They Google personal injury lawyer near me. They see the same faces on billboards that they see on late-night TV commercials, shouting about getting you the big bucks. They pick the one with the flashiest ad or the catchiest jingle. They make a call, and they walk straight from the insurance company's trap into a completely different one. Because here is the brutal truth they don't tell you on the billboard. Hiring the wrong lawyer can be just as damaging as having no lawyer at all. A bad lawyer can leave you with a settlement that's a fraction of what you deserve. They can let your case languish for years, never returning your calls, treating you like a case number instead of a human being who has been through a traumatic experience. They can buckle at the first sign of a fight from the insurance company, pressuring you to take a lowball offer just so they can close the file and collect their fee. Hiring a personal injury lawyer isn't like hiring someone to fix your plumbing. This person will be your champion, your advocate, and your guide through one of the most difficult periods of your life. They will be the one person standing between you and a multi-billion-dollar insurance corporation that wants to pay you as little as possible. Choosing the right one is everything. So how do you do it? How do you cut through the noise, the slogans, and the slick marketing to find a true warrior who will fight for you? You do it by asking the right questions. Not just any questions. You need to ask specific, strategic questions that peel back the curtain and reveal exactly what kind of lawyer and what kind of law firm you're dealing with. And over the next few minutes, I'm going to give you the 5 most important questions you absolutely must ask before you sign a single piece of paper with any personal injury attorney in the United States. These 5 questions are a lie detector. They are a vetting system. They will instantly separate the high-volume settlement mills that just want to churn through your case from the dedicated, trial-ready advocates who will actually maximize your recovery. Getting this right will change the entire trajectory of your case and potentially your life. Let's get started with the very first and in many ways the most illuminating question you need to ask. You're in their office for the initial consultation. They've listened to your story. They've told you that you have a great case. They're sliding the representation agreement across the table for you to sign. Before your pen touches that paper, you need to look them in the eye and ask this. Question number 1. Who specifically at this firm will be my primary point of contact And who will be managing the day-to-day strategy of my case? Now this sounds simple. Sounds basic. But the answer to this question is a massive red flag or a huge green light. It reveals the entire business model of the law firm you're about to hire. What you're listening for is hesitation. You're listening for vague answers. You're listening for legal jargon designed to confuse you. A bad, or at least a high-volume, settlement mill type of firm will often give you an answer like this. Well, our whole team will be working on your case. You'll be assigned a case manager, and our pre-litigation department will handle everything. Let me translate that for you. That means the impressive, experienced partner sitting in front of you right now, you will likely never speak to him or her again after you sign that paper. You've just been sold. You're being handed off. Your case is being passed down the assembly line to a case manager, who may not even be a lawyer. They could be a paralegal, maybe even a legal assistant juggling 100, 200, maybe even 300 other cases at the same time. You will not be a client, you will be a file in a stack. When you call for an update, you'll get their voicemail. When you email, you might get a one-sentence reply 3 days later. When a crucial decision needs to be made, your non-lawyer case manager will have to go find a lawyer to get approval, slowing everything down. You will feel lost, ignored, and powerless. This is the business model of firms that spend millions on advertising. They are a volume business. They need to sign up a massive number of cases and settle them as quickly as possible for as little work as possible. They make their money on volume, not on maximizing the value of any single case. Not on maximizing your case. Now let's contrast that with the answer you want to hear. The answer from a true advocate. When you ask them, who will be my primary point of contact in managing my case? The right lawyer will look you right in the eye and say something like this. I will. My name is on the door. And I am the attorney who will be responsible for your case from start to finish. You will have my direct email address and my cell phone number. Now my lead paralegal, Jessica, will be assisting me with gathering medical records and handling scheduling, and she is fantastic. But every strategic decision, every conversation with the insurance adjuster, every negotiation, and every court filing will be personally handled or approved by me. If you ever have a question or a concern that Jessica can't answer, you call me. If you get an offer from the insurance company, you and I will discuss it together. I am your lawyer. Do you feel the difference? It is night and day. One answer is a handoff. The other is a promise. One makes you a number on a spreadsheet. The other makes you a partner in your own case. This isn't just about feeling good. This has a direct and massive impact on the outcome of your case. A lawyer who is personally invested in your file, who knows the details of your medical treatment, who understands how the injury has impacted your family, that is a lawyer who can tell your story with passion and conviction to an insurance adjuster or, if necessary, to a jury. A case manager reading from a computer screen simply cannot. By asking this one simple question up front, you force them to commit. You establish a clear line of communication and accountability from day one. If they hesitate, if they give you a vague corporate speak answer about the team, you know that you are likely in a settlement mill. It doesn't mean they're bad people, but it means their business model is not aligned with your best interests. Your best interest is to get the maximum possible compensation for your unique, individual suffering. Their interest is to close a high volume of files as efficiently as possible. Those two goals are fundamentally in conflict. So, before you do anything else, ask them who specifically will be your champion. Their answer will tell you everything you need to know. And if their answer is vague, if they say, well, our team handles it, or you'll be working with one of our case managers, that's your first major red flag. It means you are likely being funneled into a system, a machine designed for volume, not for you. You need a name. You need to know that the person whose name is on the door is the same person who will be fighting for you in the trenches. This leads us directly to the second and arguably most misunderstood question you must ask. What is your fee structure? And exactly what costs am I responsible for, win or lose? Now, almost every personal injury lawyer in the United States works on what's called a contingency fee. The television commercials have drilled this into our heads. No fee unless we win. It sounds simple, right? Sounds like there's no risk. But the devil is not in the fee. He's in the costs. And the difference between the two can be the difference between a life-changing recovery and a devastating financial disappointment. Let's break this down. The contingency fee is the percentage the lawyer takes from your settlement or verdict. The industry standard is typically 1/3, or 33.3%. So, on a $100,000 settlement, the lawyer's fee would be $33,333. Simple enough. Many agreements will also have a clause that says this percentage increases, often to 40% or even higher, if the case has to be filed in court or goes to trial. This is fairly standard, as litigation is much more work-intensive. But here is the multi-thousand-dollar detail that most people miss. The attorney's fee is completely separate from the costs of pursuing your case. These are the out-of-pocket expenses the law firm pays up front to build your case from the ground up. And they can be astronomical. What are these costs? We're talking about court filing fees. Fees to have a sheriff serve the lawsuit on the defendant. The cost of ordering your medical records and police reports. But the big ones, the ones that can truly run up the bill, are deposition costs and expert witness fees. A deposition is when your lawyer questions a witness under oath before a trial. This requires hiring a court reporter, who charges for their time and for creating a transcript. That can be hundreds, sometimes thousands of dollars per witness. If you want it videotaped, add a videographer to the bill. Then you have the experts. In a serious car crash case, you might need an accident reconstruction expert to prove how the crash happened. Their job is to create a scientific, animated model of the collision. These experts can cost $10,000, $20,000, even $50,000 or more. In a medical malpractice case, you need other doctors to review the records and testify that your doctor made a mistake. A top-tier medical expert can charge over $1,000 an hour just to review records, and their fee to testify in court can be tens of thousands of dollars. All these costs, postage, copying, travel, investigators, experts, are tallied up, and they are almost always paid back to the law firm out of your settlement. This brings us to the single most important follow-up question you can ask about money. Do you take your percentage from the gross settlement amount, before costs are deducted, or from the net settlement amount, after costs are deducted? Let me show you why this is a $20,000 question. Let's go back to our $100,000 settlement. And let's say the case costs were $20,000. If the lawyer calculates their one-third fee from the gross settlement, the math looks like this. The settlement is $100,000. The lawyer's fee is one-third of that, which is $33,333. Then, you subtract the $20,000 in costs. So, you take $100,000 minus the $33,000 fee, minus the $20,000 costs. You are left with $46,667. From that, you still have to pay back your health insurance and medical providers. Now, let's see what happens if the lawyer calculates their fee from the net settlement. This is what a client-focused firm will do. The settlement is $100,000. First, they subtract the $20,000 in costs. This leaves a net settlement of $80,000. Now, the lawyer takes their one-third fee from that $80,000 net figure. One-third of $80,000 is $26,666. So, your take is the $80,000 minus that $26,000 fee. You are left with $53,334. By simply changing the way the math is done, you walk away with almost $7,000 more in your pocket. The lawyer who takes their fee from the net is essentially sharing the burden of the costs with you. They are putting their money where their mouth is. The lawyer who takes it from the gross is maximizing their own bottom line, often at your expense. You must get the answer to this in writing. But there's one more piece to this puzzle. You have to ask, and what happens if we lose? Am I responsible for paying back these costs even if I get nothing? This is a terrifying prospect. Imagine going through a grueling 2-year legal battle, losing at trial, and not only getting $0 for your injuries, but now the law firm sends you a bill for $30,000 in costs. It happens. Some firms will put a clause in their contract that makes you liable for all case expenses if you lose. A law firm that truly believes in your case, a firm that has properly vetted it and is confident they can win, will almost always absorb the costs if the case is lost. They are taking the risk with you. If a lawyer tells you that you will be on the hook for costs even if you lose, you should walk out of that office immediately. It tells you one of two things. Either they are not confident in your case, or they are not willing to take on the financial risk that is supposed to be part of the contingency fee arrangement. So this one big question, what is your fee structure and what costs am I responsible for? Is actually 3 smaller laser-focused questions. 1. What's your percentage and does it increase if we go to trial? 2. Do you calculate that percentage from the gross or the net settlement? And 3. Who pays the costs if we lose? Their answers to these questions will reveal the entire financial philosophy of the firm. It separates the partners who will fight alongside you from the predators who see you as just another number on a spreadsheet. Once you have a crystal clear understanding of how the money works, you need to understand how they work. You need to know if the lawyer sitting across from you is a warrior who actually goes to battle, or a negotiator who is afraid of the courtroom. And that brings us to the third question, a question that separates the true trial lawyers from the paper pushers, and it's a question that very few of them want to answer honestly. So what is this question? It's simple, it's direct, and it's devastatingly effective. You look them right in the eye and you ask, how many cases just like mine have you personally taken to a jury trial, and what were the results? Let's break that down because every single word in that sentence is a weapon in your arsenal. First, how many cases just like mine? This isn't a general question about their experience. If you were injured by a faulty airbag in a rollover accident, you don't care how many slip and fall cases they've handled. You need to know if they understand the complex world of product liability, accident reconstruction, and the specific medicine related to your injuries. You're asking for relevant experience. Are they a jack of all trades? Or are they a master of the craft you desperately need? A lawyer who has handled dozens of rear-end collision cases might be completely lost in a medical malpractice lawsuit. Specificity is key. It forces them to demonstrate true expertise, not just a general familiarity with personal injury law. Second, the most important part of the question, have you personally taken to a jury trial? Notice the two critical words there, personally and jury trial. Let's start with personally. You're not asking about the firm's results. Many large firms will put their charismatic, silver-haired founding partner on their billboards and TV commercials. But when you sign up, your case gets handed off to a junior associate who's never seen the inside of a courtroom. You need to know if the lawyer sitting across from you, the one whose hand you're shaking, is the one who will be fighting for you if things get tough. Or are they just a salesperson for the firm? Now for the kill shot. To a jury trial. Not settled. Not mediated. Not resolved. Taken all the way to a verdict in front of a jury of 12 ordinary citizens. Why is this the magic phrase? Because it exposes the fundamental difference between two types of personal injury lawyers, the settlement mill and the true trial lawyer. And understanding this difference is the single most important thing you can do to protect the value of your case. A settlement mill is exactly what it sounds like. It's a high-volume factory. They sign up hundreds, sometimes thousands of cases a year. Their business model is built on one thing, speed. They want to get your case in, get a quick offer from the insurance company, take their cut, and get you out the door. They work on volume, not value. To them, your case is just a number on a spreadsheet. They have no intention ever of going to trial. Why? Because trials are expensive, they are time-consuming, and they are incredibly difficult. It takes a unique skill set, a ton of resources, and nerves of steel to stand up in front of a jury and a judge and fight. The lawyers at these settlement mills? They're negotiators. They're paper pushers. They're professional phone call makers. But they are not trial lawyers. And here's the secret the insurance companies don't want you to know. They know exactly who these lawyers are. Every major insurance company in the United States keeps meticulous records on the law firms and lawyers they go up against. They have internal databases. They know which lawyers always settle cheap. They know which law firms are terrified of the courtroom. They have a book on everyone. So what happens when a lawyer from a settlement mill, a lawyer who has never tried a case, sends a demand letter to the insurance company? The insurance adjuster laughs. They know this lawyer won't fight. They know there is zero threat of going to trial. So why on earth would they offer the full and fair value of your case? They have no incentive to. It would be bad business. They'll throw out a lowball offer, maybe even a ridiculously insulting one, because they know the lawyer will likely pressure you to take it. The lawyer will say things like, "It's a sure thing," or "A bird in the hand is worth two in the bush," or "You don't want to risk getting nothing at trial." It's a scare tactic designed to get you to accept less than you deserve, so they can cash their check and move on to the next file in their stack. Now let's look at the other side of the coin. The true trial lawyer. This is a lawyer who prepares every single case as if it's going to trial from day one. They do exhaustive investigations. They hire the best experts. They take detailed depositions. They build your case brick by brick, creating an ironclad story to present to a jury. They are not afraid of the insurance company's army of defense attorneys. In fact, they relish the fight. This reputation precedes them. When a known trial lawyer sends a demand letter, the entire dynamic shifts. The insurance adjuster sits up a little straighter. They pull up that lawyer's file and they see a history of jury verdicts. They see wins. They see a lawyer who isn't afraid to roll the dice and let a jury decide. Suddenly, the insurance company's risk calculation completely changes. The risk is no longer just the settlement amount. The risk is now a runaway jury verdict that could be 5, 10, or even 20 times higher than what they could settle the case for. The risk is the massive cost of defending a lawsuit through a week-long, or even month-long trial. Because of that credible threat, the insurance company is forced to negotiate in good faith. They are motivated to offer the full, fair value of your case, or something very close to it, to avoid going to court against a lawyer they know can beat them. This is the great paradox of personal injury law. The lawyers who are the most prepared and willing to go to trial are the ones who are able to get the best settlements without going to trial. Their reputation for war is what keeps the peace. A settlement mill's reputation for peace is what gets you a lowball offer. So when you ask a lawyer, how many cases like mine have you taken to a jury trial? You're not just asking a question. You're testing their entire business model. You're finding out if they are a sheep or a wolf. And finally, the last part of the question. And what were the results? It's not enough to just go to trial. You have to be able to win. A lawyer who constantly tries cases and loses is just as dangerous as one who never tries them at all. This is where you have to listen very, very carefully to their answer. A bad lawyer, a settlement mill lawyer, will get defensive or evasive. They'll say something like, "Oh, we settle 99% of our cases for our clients." That sounds great, but it's a classic misdirection. The question isn't how many you settle. The question is, why are you able to settle them? Is it because the insurance company is terrified of you? Or is it because you're taking the first lowball offer that comes across your desk? They might say, "Well, every case is different. The results really depend on the facts." Again, this is a dodge. They're trying to avoid giving you a straight answer. A confident, experienced trial lawyer will be proud of their record. A great lawyer, a true trial lawyer, will answer the question directly and with specifics. They'll say something like, "That's a great question. In the last few years, I've personally tried 3 cases involving commercial trucking accidents. In the first one, the insurance company's final offer was $200,000. We took it to trial and the jury came back with a verdict of $1.2 million. In the second case, the offer was $50,000. The jury awarded our client $300,000. The third case was tough. We actually lost that one. The jury didn't believe our expert witness, and here's what I learned from that experience." Did you catch that last part? A truly great trial lawyer isn't afraid to tell you about their losses. Anyone who tells you they've never lost a trial is either lying or they've never been to trial. Losing is part of the game. But a lawyer who can intelligently and honestly discuss a loss demonstrates experience, humility, and self-awareness. It shows they are a real person who has been in the trenches, not some slick salesperson reading from a script. They can tell you what they learned and how it made them a better lawyer for their future clients, including you. So you're not just looking for a win-loss record. You're looking for transparency, confidence, and a track record of forcing insurance companies to pay what a case is truly worth. Whether it's in the settlement conference room or the courtroom, you've now established that the lawyer in front of you is a specialist in your type of case, and more importantly, that they are a genuine threat in the courtroom. You've confirmed you're talking to a warrior, not just a negotiator. But a great warrior is only as good as the army behind them and the attention they give to your specific battle plan. A proven track record is history. You need to know how they're going to handle your future. And that brings us to the fourth critical question, a question that peels back the curtain on the day-to-day reality of how their law firm actually operates, and whether you will be a priority or just another file in a cabinet. The question is this: who specifically will be handling the day-to-day work on my case, and what is the firm's communication policy? Now, on the surface, that sounds like simple logistics, a bit of administrative housekeeping. But I promise you, the answer to this question is a powerful X-ray into the soul of a law firm. It reveals their entire philosophy on client care. It tells you whether you're about to partner with a dedicated advocate or simply be fed into a machine. Let me tell you about a woman named Maria. Maria was T-boned by a delivery truck that ran a red light. The accident left her with a shattered pelvis and a mountain of medical bills she couldn't even bear to look at. She was scared, in constant pain, and the primary breadwinner for her family. She saw a lawyer on a giant billboard every day on her husband's drive to the hospital. He had a confident smile, a powerful slogan, and a phone number that was easy to remember. She called. The meeting was everything she'd hoped for. It took place in a stunning corner office with a panoramic view of the city. The lawyer, the same man from the billboard, was charismatic and reassuring. He listened intently, took notes, and told her, "Maria, don't you worry about a thing. We're going to take care of everything. We're going to fight for you." She felt a wave of relief so powerful it brought tears to her eyes. She signed the retainer agreement on the spot, and that was the last time she ever spoke to him. Her first call a week later was routed to a case manager named Brenda. Brenda seemed nice, but when Maria asked a specific question about the insurance company's initial response, Brenda said, "Oh, I don't handle the legal side. I just gather the documents. The attorney will look at it when they have a chance." A month later, Maria called again, worried because the hospital was now sending letters threatening to send her account to collections. She was put on hold for 15 minutes, then transferred to a different case manager. Brenda was no longer with the firm. This new person couldn't find her file at first. When he finally did, he promised an attorney would call her back. The call never came. Emails went into a black hole. Voicemails were met with silence. Maria felt like she was screaming into a void. The relief she had felt in that corner office had curdled into a constant, gnawing anxiety. Was anyone even working on her case? Did they forget about her? The billboard lawyer who promised to fight for her was a ghost. Her case, her life, her future, had been handed off to an assembly line of overworked, underinformed staff who saw her not as a person in pain, but as file #743B. This is not a rare story. It is the single most common complaint clients have about their personal injury lawyers. It's called the bait and switch. You get reeled in by the experienced, high-profile partner, but your case is immediately delegated to a junior associate, or worse, handled almost exclusively by a non-lawyer paralegal or case manager. Let me be crystal clear. There is absolutely nothing wrong with the team-based approach. In a good law firm, it's a sign of efficiency. A skilled paralegal can be a godsend for managing paperwork, collecting records, and keeping things organized. A junior associate can be fantastic for legal research and drafting motions. But you, the client, need to know who is quarterbacking the team and who you can turn to for actual legal advice. So when you ask, "Who will be handling my case?" don't accept a vague answer like, "Our whole team will be on it." Dig deeper. Ask follow-up questions. Who will be my primary day-to-day point of contact? What is that person's role? Are they a partner, an associate attorney, or a paralegal? If it's a paralegal, who is the supervising attorney? And how often will I be speaking directly with that attorney about the strategy of my case? A good lawyer will welcome these questions. They'll have a clear structure and will be happy to explain it. They might say something like, "I will be the lead attorney on your case. I will be making all of the strategic decisions, handling all negotiations, and I will be the one in the courtroom if we go to trial. My paralegal, Jessica, will be your day-to-day contact for updates on medical records and scheduling. She's fantastic and has been with me for 10 years. If you ever have a legal question or want to discuss strategy, you call me directly. If I'm in court, I'll call you back within 24 hours. That is a beautiful answer. It's clear, it sets expectations, and it shows a system designed for client communication. A bad answer, a red flag answer, is evasive. "Oh, don't worry, we have a big team. Just call the main line and whoever is available will help you." This is the language of the high-volume settlement mill. These are the firms you see advertising everywhere. Their business model is based on signing up a massive number of cases, investing minimal attorney time in each one, and pushing for quick, often undervalued settlements. They operate on volume, not value. To them, you are a number. Your case is a cog in a machine designed to churn out fees. If your case is a straightforward, minor car accident with no complex injuries, maybe that's okay for you. But if you have a serious injury, if your life has been turned upside down, you do not want to be a cog in a machine. You need an advocate. This brings us to the second half of the question. And what is the firm's communication policy? This is where you lock them down. This is where you prevent the Maria experience. Don't ask, "Will you keep in touch?" Of course they'll say yes. You need specifics. Ask, "What is your policy for returning phone calls and emails? Is it 24 hours? 48 hours? Ask, "How will I receive updates on my case? Will it be by phone, email, or through a client portal? And how often can I expect to hear from you? Even if there's no major news." This last part is key. A lot of the legal process is just waiting. waiting for medical records, waiting for the insurance company to respond, waiting for court dates. Good lawyers understand that this silence is terrifying for a client. A great firm will have a policy to check in with clients every 30 or 45 days, even if there is nothing new to report, just to say, "Hi, we haven't forgotten you. Here's what we're waiting on. We're still on track. Do you have any questions?" That simple, proactive communication is priceless for your peace of mind. If a lawyer scoffs at this or gives you a vague answer like, "We'll call you when something happens," you should be very, very wary. They're telling you upfront that they don't prioritize client communication. They are telling you that your peace of mind is not their concern. They are telling you that you will spend months, maybe years, staring at your phone, wondering what on earth is going on with the case that will determine your family's future. You are not an inconvenience. Your questions are not a nuisance. You are the client. You are the one who is hurt. You are the one whose life is in turmoil. You are hiring them for a service, a profoundly important service. You have every right to expect and demand clear, consistent, and compassionate communication. The answers to this fourth question will tell you everything you need to know about the respect they show their clients. A lawyer who can't give you a straight answer about who will be working on your case and how they'll communicate with you is a lawyer who is, in all likelihood, hiding a dysfunctional, disorganized, or client-unfriendly operation. But let's assume you find the perfect firm. They have the trial experience. They have the right specialty. Their communication policy is a dream come true. You're ready to sign. But there's one last hurdle. One final question that stands between you and your chosen advocate. This last question is about the one thing that can create a massive, hidden conflict of interest between you and your lawyer. It's a question about money. Not just how much they charge, but how they charge and how the costs of your case are handled. The answer can mean the difference between you walking away with the bulk of your settlement, or watching in horror as it gets devoured by unexpected fees and expenses you never saw coming. It is the single most important financial question you will ever ask them. So what is this powerhouse question? It's not just one question, but a three-part missile of financial clarity that you need to launch in that initial consultation. Get your notepad ready. You need to ask them this word for word. Could you please walk me through your entire fee structure, including the contingency fee percentage, how and when case costs are calculated and deducted, and can you provide me with a sample settlement breakdown so I can see how it all works in practice? Let's dismantle that. This isn't an aggressive question. It's an intelligent one. And any lawyer who is proud of their transparent, client-first practice will welcome it. Any lawyer who squirms, who gets defensive, who gives you a vague, hand-waving answer. Well, you just got your answer, didn't you? First, let's look at the contingency fee percentage. This is the part most people think they understand, but the devil is always in the details. A contingency fee means the lawyer only gets paid if they win or settle your case. No recovery, no fee. It's the classic, we don't get paid unless you get paid line. And that's great. It gives you access to legal representation you might not otherwise be able to afford. The industry standard typically hovers around 33.33%, or 1/3, of the total settlement if the case is resolved without filing a lawsuit. But here's where you need to pay attention. Many fee agreements have what's called a sliding scale. This means that percentage isn't fixed. The moment a lawsuit is formally filed with the court, that 33% can instantly jump to 40%. Why? Because filing a lawsuit triggers a whole new, much more expensive and time-consuming phase of the legal process called litigation. There are depositions, formal discovery, endless motions. It's a lot more work. If the case proceeds all the way to a trial, that fee might climb again to 45%. And if, God forbid, there's an appeal after the trial, it could go even higher. You need to know exactly what those trigger points are. Is it the moment the lawsuit is filed? Is it 90 days before trial? Is it on the first day of trial? You need to know the exact milestones that will cause their share of your recovery to increase. A vague answer like, "Oh, it's the standard 33 to 40, is a massive red flag. It's your money. You deserve a precise answer, and you 100% need to see that sliding scale spelled out in black and white in the fee agreement you sign. Now for the second and arguably most misunderstood part of our question. How and when are case costs calculated and deducted? Listen closely, because this one concept can swing your final payout by thousands or even tens of thousands of dollars. Case costs, sometimes called expenses, are the out-of-pocket funds the law firm fronts on your behalf to build and prosecute your case. This is separate from their fee. This is them paying for the ammunition needed to win the war. We're talking about things like court filing fees, the cost of ordering all your medical records and police reports, fees for expert witnesses, which can be astronomical. Think of a surgeon or an accident reconstruction engineer who charges $500 an hour, the cost of taking depositions, which involves paying for a court reporter and sometimes a videographer. These costs can easily run into the thousands, and in a complex case, tens of thousands of dollars. Now, everyone agrees these costs need to be paid back to the law firm from the settlement. That's fair. They took the risk. But here is the multi-thousand-dollar question. Are those costs deducted from the settlement before or after the attorney's 1/3 or 40% fee is calculated? Let me show you why this is so critically important. Let's imagine you get a $100,000 settlement. And let's say the case costs were $10,000. Your lawyer is on a 40% contingency fee because a lawsuit was filed. Now let's look at scenario A, the method that is far worse for you. The lawyer calculates their fee off the top, from the gross settlement. So, they take 40% of the full $100,000. That's a $40,000 fee for them. Now you have $60,000 left. From that $60,000, they then deduct the $10,000 in case costs. So, after the lawyer's fee and the costs, you are left with $50,000. Before you even pay your medical bills. Now let's look at scenario B, the much more client-friendly method. In this scenario, the costs are taken out first. So, from the $100,000 settlement, we first subtract the $10,000 in costs. That leaves a net settlement of $90,000. Now, the lawyer calculates their 40% fee, but they calculate it based on that smaller $90,000 number. 40% of $90,000 is $36,000. That's their fee. So, from the $90,000, you subtract the $36,000 lawyer's fee. And what are you left with? $54,000. In this simple example, the way the math is done creates a $4,000 difference in your pocket. For $1,000, that could be physical therapy you need. That could be a down payment on a car to get you back to work. It's your money. And the only difference was the order of operations. You absolutely must hire a lawyer who calculates their fee from the net settlement, after costs are deducted. If they get defensive about this, if they say that's not how we do it, thank them for their time and walk out the door. There are plenty of excellent ethical lawyers who put their clients first and do the math the right way. Finally, the third part of our power question. Can you provide me with a sample settlement breakdown? This is the ultimate transparency test. Asking for this shows them you are a sophisticated consumer. You're not just taking their word for it, you want to see the proof. A settlement breakdown, sometimes called a closing statement or a distribution summary, is the final accounting sheet in a case. It's a simple document that shows all the math on one page. It should clearly list: Line 1, the gross recovery amount. In our example, $100,000. Then a list of deductions. Line 2, attorney's fees. In our good example, $36,000. Line 3, itemized case costs. This shouldn't just be a lump sum of $10,000. It should be broken down. $250 for filing fees, $1,200 for medical records, $5,000 for Dr. Smith's expert report, $3,550 for deposition transcripts, and so on. You have a right to see exactly what you're paying for. Line 4, medical liens and bills paid. This is where they list the payments made directly from the settlement to your health insurer, to the hospital, to the chiropractor to satisfy your outstanding bills. And the final beautiful bottom line, net to client. The exact amount of the check that will be handed to you. When you ask for a sample, they obviously won't give you a real client's confidential information. They will give you a redacted version or a hypothetical template that they use. And that's perfectly fine. The point is to see their process, to see if they are organized, transparent, and willing to show you exactly how they account for every single penny. A great lawyer will have this ready. They'll be proud to show you. Absolutely, here's how we do it. We believe in total transparency. A lawyer who hesitates, who says, "Oh, it's very complicated," or "every case is different," is hiding something. Yes, every case is different, but the format for honest and clear accounting is not. It's universal. Demanding to see this isn't rude. You are potentially entrusting this person with your financial future. You are hiring them to manage what could be the largest single financial transaction of your life. You have every right to see how they handle the books before you sign on that dotted line. So to recap, this one three-pronged question about fees, costs, and the settlement breakdown is your ultimate financial shield. It cuts through the sales pitch and gets right to the heart of the business relationship. It establishes you as a serious, informed client and sets a precedent of transparency from day one. Answering this question to your satisfaction is the bare minimum. It's the cost of entry for any lawyer who wants the privilege of representing you. Now, once you've secured your financial understanding, once you know exactly how the money will flow, you might think you're ready to sign. But hold on. Because having the best fee agreement in the world means nothing if the person you just hired disappears, never to be heard from again. And that brings us to our next critical question, a question that uncovers the true day-to-day reality of what it's like to be a client at their firm. Question number 3. Who specifically will be handling my case, and what is your firm's communication policy? This question might sound simple, almost administrative, but I assure you the answer to this question separates the law firms that see you as a person from the ones that see you as a file number. It cuts right through the marketing, the billboards, the fancy commercials, and gets to the heart of what your experience will actually be like for the next several months or even years. Let me paint a picture for you. It's a scene that plays out in law offices across America every single day. You walk in for your free consultation, nervous but hopeful. You sit down across a big mahogany desk from the senior partner, the one whose face is on the side of the bus. He's charismatic, he's confident. He listens to your story, pats you on the shoulder and says, "Don't you worry, we're going to take care of you. We're going to fight for you." You feel a massive wave of relief. You sign the paperwork, you shake his hand, and you walk out feeling like you've got a heavyweight champion in your corner. And then you never speak to him again. Ever. Your calls go to a junior associate you've never met. Your emails are answered 2 days later by a paralegal whose name you don't recognize. The champion you thought you hired has tagged out, and you've been handed off to the undercard. This is the legal world's classic bait and switch. And it's not just frustrating, it's terrifying, because your life has been turned upside down. You're in pain. You can't work. The bills are piling up. And the one person you trusted to guide you through this storm is suddenly a ghost. Your case isn't just a stack of papers. It's your life. It's the story of what happened to you, the pain you're enduring, the impact on your family, your fears about the future. The person handling your case needs to understand that story. They need to know you, and you need to know, trust, and be able to reach them. So when you ask, "Who will be handling my case?" you need to listen for the specifics. A vague answer like, "Oh, our team will take care of it," is a giant red flag. What team? Who is on this team? You need to press for details. A good answer sounds like this: "I will be the lead attorney on your case. I will be responsible for all major strategic decisions. I will handle all negotiations. And if we go to trial, I will be the one in the courtroom with you. You will also be working very closely with my senior paralegal, Sarah. She has 15 years of experience and is an absolute rock star at managing the day-to-day aspects, like collecting medical records and coordinating with insurance adjusters. The two of us work as a unit. You can contact either of us, and we keep each other constantly updated." See the difference? That's clarity. That's a structure. You know who the players are and what roles they play. If they tell you that a junior associate will be heavily involved, that's not necessarily a bad thing, but you should ask to meet them. Ask about their experience. The key is that there should be no surprises. You should leave that meeting knowing exactly who is on your team. The second part of the question is just as critical. What is your firm's communication policy? This is where you set expectations from day one. I cannot overstate how much anxiety and frustration in personal injury cases comes from one simple thing: silence. When you don't hear from your lawyer, your mind starts to race. Did they forget about me? Are they even working on my case? Did the insurance company deny my claim and nobody told me? Silence breeds doubt and fear. A great law firm understands this. They don't just practice law. They manage client anxiety. And they do that with a clear, proactive communication policy. So when you ask this question, you're not just looking for a nice sentiment like, "We believe in good communication." You are looking for a system, process. You need to ask follow-up questions to uncover that system. First, ask about frequency. How often can I expect to receive updates on my case? Even if there's no new information, a good firm will have a standard answer. It might be, "We send out a status update email every 30 days, regardless of what's happening, just so you know we're still on it." Or, "You can expect a call from your paralegal at least once a month to check in and see how your medical treatment is progressing." A firm that hasn't thought about this, that says, "Oh, we'll just call you when something happens," is a firm that's going to leave you in the dark for long, stressful stretches of time. Second, ask about response times. If I call or email with a question, "What is your firm's policy for getting back to me?" the answer should be specific. We have a 24-hour rule. We will respond to every client call or email within 1 business day. That is a promise. It's a standard of service. If they hesitate or say, "Well, we're very busy, we'll get back to you as soon as we can," that's another red flag. Of course they're busy. You're busy recovering from a major injury. Your peace of mind deserves a place on their to-do list. Third, ask about the method. How do they prefer to communicate? How do you prefer to communicate? Are they comfortable sending text message updates for minor things? Do they have a secure online client portal where you can log in and see the status of your case and all the relevant documents 24/7? Modern, client-focused firms are adopting this technology because it provides transparency and empowers the client. It puts you in the driver's seat. An old-school firm that only communicates through formal letters sent by snail mail might not be the right fit for you in the 21st century. Let me tell you a quick story about a client we'll call David. David was in a serious motorcycle accident. He hired a big TV law firm, and for the first 6 months he felt completely lost. He'd call and leave messages that were never returned. He'd send emails that went into a black hole. He had no idea what was happening with his medical bills or his claim. The stress of not knowing was worse than the physical pain of his recovery. He finally got fed up and switched to a different firm. The first thing his new lawyer did was sit him down and walk him through their communication plan. He introduced David to the paralegal, gave him his direct cell phone number for emergencies, and showed him how to use their client portal. The lawyer told him, "David, you will never have to wonder what's going on with your case again." And he was right. David said later that the moment he switched firms, it felt like a 1,000-pound weight had been lifted off his chest. The case outcome was great, but what he remembers most is the feeling of being respected, informed, and cared for. That's what you're looking for. You're not just hiring a legal technician, you're hiring a guide, partner. The legal process is a confusing, intimidating journey. A good lawyer doesn't just walk the path for you. They hold a lantern and walk it with you, explaining the twists and turns along the way. So when you're in that consultation, don't be shy. Ask the tough questions about communication. Who am I talking to? How often? How quickly will you respond? The lawyer who has clear, confident, and client-focused answers to these questions is the lawyer who understands that their most important job isn't just winning your case. It's earning your trust every single day until they do. Now, once you've established who you'll be working with and how you'll communicate, you need to dig into the nuts and bolts of their actual experience. Not just general experience, but specific, relevant, battle-tested experience with cases just like yours. And this next question is designed to separate the true specialists from the generalists who just happen to take on a few injury cases on the side. So you're sitting across from this lawyer and you need to ask, question number 3, what percentage of your practice is dedicated not just to personal injury, but specifically to cases like mine? And can you share some recent, relevant case results? This question is a laser-guided missile. It's not a shotgun blast. It has 3 distinct parts, and each one is designed to strip away the marketing fluff and get to the hard, verifiable truth. Let's dismantle it. First part. What percentage of your practice is dedicated to personal injury? This is the first filter. You see, many law firms are like a buffet. They offer a little bit of everything. A divorce on Monday, a real estate closing on Tuesday, a DUI on Wednesday, and maybe if one walks in the door, a car accident case on Thursday. They are general practitioners. And while they might be perfectly competent lawyers, you have to ask yourself a critical question. If you needed brain surgery, would you go to your family doctor? Or would you seek out a neurosurgeon? You'd want the specialist. The person who does that one thing day in and day out, and knows every single nerve, every vessel, every possible complication. Personal injury law is its own complex universe. It's not just filling out forms. It's a high-stakes battle against multi-billion-dollar insurance corporations. These companies have armies of lawyers and adjusters whose entire job, their sole purpose on this earth, is to figure out how to pay you as little as possible, or better yet, nothing at all. A generalist lawyer who spent yesterday drafting a will is walking into that war with a butter knife. A true personal injury specialist is walking in with a tactical plan, night vision goggles, and the coordinates for an airstrike. They've seen every trick in the insurance company's playbook because they fight against it every single day. They know the local judges, they know which expert witnesses are the most credible, and they know what a jury in your specific county is likely to award for a specific injury. That knowledge isn't learned in a book. It's earned in the trenches. So when you ask this question, you don't want to hear, "Oh, we handle a variety of cases." That's a dodge. You want to hear a number. 95% of our work is personal injury. Or, our firm is exclusively dedicated to representing injury victims. It's all we do. That is the sound of a specialist. That is the sound of focus. But we're not done. That's just the first part of the question. The second part is where you really turn up the heat. Specifically to cases like mine, this is crucial. Because even personal injury is a massive category. Think about it. A case involving a slip and fall on a wet floor at a supermarket is completely different from a case involving a complex, multi-vehicle pileup on the interstate. A dog bite case has different laws and standards of proof than a medical malpractice case, which is an entirely different galaxy of complexity. Let's say you were injured by a defective airbag in your car. That's a product liability case. It requires engineers, manufacturing experts, and a deep dive into corporate design documents. The lawyer who has won millions for clients in trucking accidents, while incredibly skilled, might know next to nothing about proving a product defect. Their skills don't transfer perfectly. You need the lawyer who has already fought Ford or Toyota or Takata and knows exactly where they hide the skeletons. So you need to be specific. I was hit by a driver who was texting. How many distracted driving cases have you personally handled in the last 3 years? Or, my mother was injured in a nursing home. What is your firm's specific experience with nursing home neglect cases? You're not just looking for a personal injury lawyer. You're looking for your personal injury lawyer. One who has walked this exact path before, who knows where the landmines are buried, and who has a map to the other side. A vague answer here is a massive red flag. If they can't speak with confidence and detail about their experience with your specific type of case, they are not the expert you need. And that brings us to the final, most important part of the question, the knockout punch. And can you share some recent relevant case results? This is the moment of truth. This is where they have to show their work. Talk is cheap. Every lawyer's website is filled with promises of aggressive representation and maximum compensation. Those are just words. Results are facts. Now, here's how to interpret their answer, because it's not just about the final number. A lawyer who says, "We got $1 million settlement last year," sounds impressive. But a great lawyer will give you the context that truly matters. When they start sharing results, you should be listening for a story. A story that sounds something like this. Absolutely. Just last year, we represented a woman who was in a situation very similar to yours. She was T-boned at an intersection by a driver who ran a red light. The initial offer from the insurance company was $12,000, which barely covered her emergency room visit. They claimed her injuries were just soft tissue, and that she'd be fine in a few weeks. We knew that was nonsense. We immediately hired an accident reconstruction expert to prove the speed of the other driver. We had our client see a top orthopedic specialist, not the insurance company's doctor, who diagnosed a serious disc herniation in her neck that would require future surgery. We took a recorded deposition of the at-fault driver, who admitted under oath that he was trying to change the radio station. We packaged all of this up, sent it to the insurance company with a deadline, and showed them that we were fully prepared to go to trial. Their $12,000 offer? It turned into a $450,000 settlement. Do you see the difference? That's not just a number. That's a demonstration of value. That story tells you everything. It tells you they're not afraid to spend money on experts. It tells you they have a network of trusted doctors. It tells you they know how to dismantle the insurance company's arguments. It tells you they pushed a case from a tiny nuisance offer to a life-changing result. That is the kind of detail you are looking for. And don't be afraid to ask follow-up questions. In that case you mentioned, how long did it take to resolve? What was the biggest challenge you had to overcome? Were any of the insurance adjusters or opposing lawyers people you dealt with before? Of course, lawyers have to protect client confidentiality. They can't give you names or identifying details. But they absolutely can and should be able to anonymize the facts and walk you through their process and their victories. If a lawyer gets defensive or is vague or just says, "Trust me, we get great results," without providing any concrete verifiable examples, you should stand up, thank them for their time, and walk out the door. This three-part question in a single breath forces a potential lawyer to prove three things: that they are a focused specialist in personal injury, that they are an experienced expert in your specific type of case, and that they have a track record of adding significant value and achieving real-world results. Answering this question correctly requires a combination of experience, transparency, and confidence. And any lawyer who can't nail this answer is not the lawyer you want in your corner. Okay, so you've found a lawyer who is a legitimate, battle-hardened specialist in your type of case. They've shown you the proof. You're feeling confident. But here's where a lot of people make a massive mistake. They get so impressed with the resume that they forget to ask about the single most important factor that will determine their sanity and peace of mind over the next several months, or even years. And that's exactly what our fourth question is designed to uncover. Question number 4 is, who will be my primary point of contact? And what is your firm's communication policy? This question seems simple, almost administrative. But I am telling you, the answer to this question will define your experience. It is the dividing line between clarity and confusion, between feeling like a valued client and feeling like a case number lost in a dusty filing cabinet. The number one complaint clients have about lawyers, across all fields of law, not just personal injury, is a lack of communication. It's a silent epidemic of neglect that causes more stress and anxiety than the legal battle itself. Let's break this question down because there are two critical parts. First, the who. When you walk into that initial consultation, you're often meeting with the firm's rainmaker. This could be the founding partner, the face on the billboard, the lawyer with decades of experience and a corner office. They are charming, confident, and they make you feel like you're in the best possible hands. You sign the paperwork, feeling a massive wave of relief. Then you never speak to them again. Your case is handed off to a junior associate who just passed the bar 6 months ago, or a paralegal or a case manager who isn't a lawyer at all. Suddenly, the person you entrusted with your future, the person whose expertise you're paying for, is completely inaccessible. This is the classic law firm bait and switch. You were sold the master chef, but your meal is being cooked by an apprentice in the back kitchen you've never even met. So when you ask, who will be my primary point of contact? You need to listen for the specifics. If they say, you'll be working with our team, that's a potential red flag. Ask for a follow-up. Can I meet the specific paralegal or associate who will be assigned to my case? Will that person be my dedicated point of contact for the entire duration of the case? If they hesitate or if they can't give you a name, be wary. Many large, successful firms operate on a team model, and it can be very effective. They might have a paralegal handle the day-to-day paperwork and record collection, while an associate handles legal motions, and the senior partner steps in for key negotiations or trial. There's nothing inherently wrong with this, but you have the right to know this structure up front. You need to understand who you call for what. Who do you call when you have a question about your medical treatment? Who do you call when you want to discuss a settlement offer? And most importantly, how much access will you have to the actual attorney making the strategic decisions on your case? If your day-to-day contact is a case manager or paralegal, you must understand a critical limitation. They cannot give you legal advice. They can give you factual updates. Yes, we received the records from the hospital, or no, the insurance company hasn't responded yet. But they cannot advise you on whether to accept a settlement offer or explain the legal nuances of a deposition. For that, you need a lawyer. So a key follow-up question is, if my case manager can't answer a legal question, what is the process and timeline for getting an answer from the attorney? This brings us to the second, equally important part of the question. What is your firm's communication policy? This is where you separate the professionals from the amateurs. A vague, non-committal answer is a siren-blaring, 5-alarm red flag. If their answer is, oh, don't worry, we pride ourselves on great communication, we'll be in touch, that's not an answer. That's a platitude. It's a verbal pat on the head. A professional firm has a system. They have a policy. They should be able to articulate it to you clearly and confidently. You need to ask for specifics. How often can I expect to receive proactive updates on my case, even if there's no new information? The answer should be something concrete, like we send a monthly status update email to all our clients, or we schedule a check-in call every 60 days. The worst feeling in the world is sitting by the phone for 4 months, wondering if your lawyer has fallen off the face of the earth. Proactive updates, even if they just say no new developments, are a sign of a firm that respects you and your peace of mind. Next, ask, what is your firm's policy for responding to my calls and emails? Again, you're listening for specifics. A great answer sounds like this. Our firm policy is to return all client communications within 24 business hours. You'll get a response from your paralegal within a day, and if they can't answer the question, they will schedule a call for you with the attorney. A bad answer sounds like this. We get back to people as soon as we can. We're very busy. Yes, they are busy. But a well-run business has systems in place to handle being busy. Your case is your entire life right now. To them, it's one of 100 files. Their internal systems are what ensure your life doesn't get lost in their pile. Let me tell you about two clients. We'll call them David and Maria. David was in a serious T-bone collision. A truck ran a red light. His injuries were significant, requiring surgery. He hired a big flashy firm from a TV commercial. He met the senior partner who was brilliant. David signed on the spot. Then silence. For 3 months he heard nothing. His medical bills were being sent to collections. He was getting threatening calls. He started calling the law firm. He'd leave a message with the receptionist. No one would call back. He'd email the main partner. No response. He finally got a paralegal on the phone who said, "Oh, we're still waiting for some records." She was dismissive and sounded annoyed that he was even calling. David's anxiety went through the roof. He was in physical pain from the accident, and now he was in mental and emotional agony from the feeling of being completely abandoned and powerless. The stress from the lawsuit was becoming worse than the stress from the injury itself. Now let's look at Maria. She had a similar accident. She went to a firm and asked our question, "Who is my contact and what's your policy?" They told her, "Your dedicated paralegal will be Jennifer. She will be your primary contact for all administrative matters. Your attorney will be Mr. Evans. Jennifer will provide you with a written status update every 30 days. Our policy is to return all calls and emails within 24 business hours. For any legal questions Jennifer can't answer, she will schedule a call with Mr. Evans for you within 48 hours. 2 months into her case, Maria was worried about her bills. She emailed Jennifer. The next day she got a call back. Jennifer said, "Maria, I'm so glad you called. We've sent letters of protection to all your doctors so they can't send you to collections. They will be paid directly from the settlement. As for your case status, we've received all your medical records, and we're drafting the demand letter to the insurance company now. Mr. Evans reviewed your file this morning and feels we're in a very strong position. Look at the difference. David is in the dark, panicked, and feels like a burden. Maria is informed, reassured, and feels like part of a team. They have the exact same type of case, but their experiences are worlds apart. The difference wasn't the quality of the lawyer's resume. It was the quality of the firm's communication system. You are not just hiring an expert. You are entering into a long-term professional relationship during the most vulnerable time of your life. You need a partner, not a ghost. So when you're in that meeting, don't be shy. Press for details. Ask to meet the paralegal. Ask for a copy of their communication policy in writing. How they respond to this line of questioning will tell you everything you need to know about what the next year of your life is going to look like. Once you've found a lawyer who is experienced, has a track record of trial success, fits your personality, and has a rock-solid communication plan, you might think you're ready to sign. But if you sign that contract without asking our fifth and final question, you could be setting yourself up for a shocking and devastating surprise when your case finally settles. And that question is all about the money. Question number 5 is the one that separates a good outcome from a financially devastating one. It's the question that can mean the difference of tens, or even hundreds of thousands of dollars in your pocket at the end of your case. It's the question most people are too intimidated, or simply too uninformed, to ask. And it is this: how exactly are case costs handled? And more importantly, is your fee calculated before or after those costs are deducted from the settlement? Now, that might sound like technical jargon, like something only an accountant would care about. But I promise you, understanding the answer to this question is the single most important financial detail of your entire personal injury claim. Let's break it down, because this is where the shell game can happen. First, you need to understand there are two different kinds of money we're talking about. There's the attorney's fee, and then there are the case costs. They are not the same thing. The attorney's fee is the percentage they take for their work, their time, their expertise. That's the contingency fee we've talked about, typically 1/3, or 40% if the case goes into litigation. But case costs, that's a completely different bucket of money. Case costs, or expenses, are the actual out-of-pocket funds the law firm spends to build and prosecute your case. Think of it like this: the law firm is essentially giving you a loan to fund your lawsuit. They are fronting all the money needed to fight the insurance company, and they only get paid back if you win. And what do these costs include? Well, it's not just a few bucks for postage stamps. We're talking about serious money. There are the court filing fees, which can be hundreds of dollars just to get your lawsuit started. There's the cost for a process server to formally deliver the lawsuit to the person you're suing. There are the fees for ordering all of your medical records and police reports. But where it really gets expensive is in discovery and litigation. When your lawyer takes a deposition, that's a formal sworn interview of a witness, a doctor, or the defendant. They have to hire a court reporter. That court reporter charges by the page to create a transcript. That can easily be $1,000 or more for a single deposition. Want it videotaped? That's another fee for a videographer. And then there's the biggest cost of all: expert witnesses. In any serious injury case, you can't just walk into court and say, "My back hurts, pay me." You need experts. You might need a medical expert, a doctor who will review all your records and testify about the extent of your injuries, their cause, and your prognosis for the future. A top-tier medical expert can charge $10,000 just to review the records and write a report, and another $10,000 or $20,000 to testify in court. You might need an accident reconstructionist, an engineer who visits the scene, analyzes the vehicle damage, and creates a scientific, computer-animated recreation of the crash to prove who was at fault. That can be $25,000. You might need a vocational expert to testify about how your injuries will prevent you from working in the future, and an economist to calculate the exact dollar amount of your lost lifetime earnings. Each of these experts costs a fortune. It is not uncommon for the total case costs in a complex, heavily litigated case to exceed $50,000, $75,000, or even $100,000. So, here is the multi-million-dollar question. When it's all over, and you get that big settlement check from the insurance company, how is the money divided? Let's imagine you settle your case for $300,000. And let's say your attorney's fee is 40%, and the case costs added up to $40,000. There are two ways this can be calculated, and the way it's written in your contract will change your life. Method A is calculating the fee from the gross settlement. This is the method that benefits the lawyer most. Here's how it works. The settlement is $300,000. The lawyer first calculates their 40% fee from that top-line number. So, 40% of $300,000 is $120,000. That goes to the lawyer. Then, from the remaining $180,000, they deduct the $40,000 in case costs. So you are left with $140,000 in your pocket. Not bad, but watch this. Method B is calculating the fee from the net settlement. This is the method that benefits you, the client. Here's how that math works. The settlement is $300,000. The lawyer first deducts the $40,000 in case costs they fronted. That leaves a net amount of $260,000. Now, the lawyer calculates their 40% fee from that smaller net number. 40% of $260,000 is $104,000. That goes to the lawyer. And what are you left with? You are left with $156,000. That is a $16,000 difference. It is your money. The work done was the same. The result was the same. The only difference was one sentence in the fine print of the contract you signed. One method puts an extra $16,000 in your lawyer's pocket. The other puts it in yours. Now imagine if that was $1 million settlement. The difference could be over $50,000. Let me tell you about a woman named Brenda. She was in a terrible trucking accident. Her injuries were life-altering. After 3 long years of fighting, her lawyer called with amazing news. They had secured a $1 million settlement. Brenda broke down in tears. She had over $150,000 in medical bills, and she'd never work again. This money was her future. She knew the lawyer's fee was 40%, so she figured she'd get around $600,000. It would be enough to pay off her bills, make her home accessible, and live without constant financial terror. She went into the office to sign the final paperwork. Her lawyer slid a document across the table. It was the settlement statement. She scanned down the page. Gross settlement, $1 million. Attorney's fee, 40% minus $400,000. Case costs, minus $95,000. Medical liens and bills to be paid, minus $150,000. Net to client, $355,000. Brenda's heart sank. She stared at the number, $355,000. It was a lot of money, but it was nowhere near the $600,000 she had been counting on. Her lawyer was getting more than she was. She looked at him, confused, betrayed. He just pointed to the fee agreement she'd signed 3 years prior. It was all there in black and white. Fee to be calculated on the gross recovery. She had signed it. It was legal. It was binding. And it had just cost her $60,000. Do not be Brenda. You must ask this question directly. Is your fee calculated on the gross settlement or on the net settlement after costs are deducted? There is no right or wrong answer from a legal perspective, but a firm that calculates its fee on the net is, without question, a more client-focused firm. It shows they are truly partners in the outcome, sharing in the expenses of the case. If they say they calculate on the gross, you can and should try to negotiate it. If they won't budge, you need to seriously consider if they are the right firm for you. And there's one final, critical follow-up to this question. What happens if we lose? Am I responsible for paying back the case costs? The answer from any reputable personal injury firm should be an immediate and unequivocal no. The entire basis of a contingency fee agreement is that the law firm assumes all the risk. If they don't win you any money, you owe them nothing. Not for their time and not for the case costs. If a lawyer tells you that you would be on the hook for the tens of thousands of dollars in expenses if you lose, you need to run, not walk out of that office. That is a massive red flag that they either don't have the financial resources to handle a real case, or they are not operating under the standard ethical practices of the profession. So now you have it. The 5 essential questions. You've grilled them on their specialty, their trial record, your point of contact, their communication policy, and the critical details of their fees and costs. You've found the perfect lawyer. You've avoided the pitfalls, dodged the bullets, and you're ready to sign on the dotted line, confident you've made the right choice. But this is where the biggest danger of all comes in. Because the moment you sign that contract, the power dynamic shifts. And the most devastating mistakes that can destroy your case are not the ones your lawyer makes, but the ones you are about to make yourself. The single greatest predictor of a case going south isn't a bad lawyer. It's a good client who doesn't know the rules of the game. You've just hired a professional to fight for you, but the other side, the insurance company, isn't going to fight your lawyer. They're going to fight you. And they will use your own innocent, everyday actions as their primary weapons. So let's talk about the 3 silent killers that can destroy your case from the inside out, long after you've hired the perfect attorney. The first and most lethal is the social media landmine. Let me tell you about a client we'll call David. David had a severe spinal injury from a commercial trucking accident. He was in constant, debilitating pain. He couldn't work, he couldn't play with his kids, his life was a shadow of what it once was. His case was rock solid. Medical records documented the injury. Expert witnesses confirmed the long-term prognosis. We were heading towards a 7-figure settlement. Then, one sunny Saturday, David's wife convinced him to get out of the house. They went to a friend's backyard barbecue. For 10 minutes, just 10 minutes, he felt okay enough to stand by the grill and flip a few burgers for his kids. His friend snapped a picture. A smiling dad at a barbecue. A picture of a moment of relief in a sea of pain. He posted it on Facebook and tagged David. Great to see you up and about, buddy. 2 weeks later, in a mediation room, the defense attorney slid that photo across the table. Printed in glossy, full color. This is your client, he said. The man you claim is in debilitating, constant pain? The man who can't work? He looks perfectly fine to me. In that instant, that one single photo, hundreds of thousands of dollars of case value evaporated. It didn't matter that for the other 23 hours and 50 minutes of that day, David was lying in bed with ice packs. It didn't matter that he paid for that 10 minutes of standing with 3 days of agony. The picture told a different story. A simple, powerful, and devastatingly false story. Insurance companies have entire departments, staffed by investigators, whose only job is to live on your social media. They will scroll back years. They are looking for anything. A picture of you on a hike from before the accident that they can use to argue you had a pre-existing active lifestyle. A check-in at a restaurant. A comment on a friend's post. A happy birthday message that sounds a little too cheerful. They will twist every post, every photo, every single word into a weapon. The single most important piece of advice your lawyer will give you is this: go dark. I don't mean set your profile to private. That is not enough. An investigator can friend your friend, or your cousin or your coworker and see what you're tagged in. I mean deactivate. Vanish from Facebook, from Instagram, from TikTok, from every platform until your case is over. Your digital life can and will be used against you in a court of law. Do not give them the ammunition. The second silent killer is what I call the tough guy syndrome. It happens in the one place you'd least expect it. The doctor's office. You go in for your follow-up appointment. The doctor asks, "So, how are you feeling today?" And what do most of us do? We're conditioned to be polite, to not be a complainer. We say, "Oh, I'm doing okay, doc. A little sore, but I'm managing." Or, "It's not as bad as last week." We downplay it. We try to be tough. And in doing so, we commit case malpractice on ourselves. You have to understand something fundamental. In a personal injury case, your medical records are not just notes. They are the entire foundation of your house. They are the official legal story of your injury. If your pain is not documented in those records, then in the eyes of the insurance company and a potential jury, it does not exist. Every time you tell your doctor, "I'm okay," or "I'm managing," the doctor writes it down. Patient reports feeling okay. Patient states pain is manageable. And the defense attorney will take those notes, blow them up on a giant poster board in front of a jury and say, "Ladies and gentlemen, these aren't my words. These are the words of the plaintiff himself, told to his own doctor. He was okay. He was managing." His own medical records tell a story of someone who was getting better, not someone who deserves $1 million. You must be brutally, specifically, and relentlessly honest with your medical providers. If your pain is a 7 out of 10, you say it's a 7 out of 10. If you couldn't sleep because your shoulder ached, you tell them. If you couldn't pick up your child, you tell them. If you had a shooting pain down your leg when you tried to get the mail, you tell them. Be specific. Be honest. And never ever miss a scheduled appointment. A missed physical therapy session or a canceled doctor's visit is a gift-wrapped present to the defense. They will argue, if he was in as much pain as he claims, wouldn't he have gone to his appointment? His actions show he wasn't that hurt. Your medical treatment is your job now. Show up. Be honest. Document everything. It is the single most powerful evidence you have. The third silent killer is the most basic human instinct of all, talking. After a traumatic event, we want to talk about it. We want to explain our side of the story. And that instinct is a trap. The moment an accident happens, an opposing insurance adjuster will often call you. They will be the nicest person you have ever spoken to. They'll sound concerned, empathetic. "I just want to get your side of the story real quick," they'll say. "Can I just record this call so I have it for my notes?" The answer to that question is always, unequivocally, no. You can speak with my attorney. That adjuster is not your friend. They are a highly trained professional whose goal is to get you to say something, anything, that they can use to deny or devalue your claim. They will ask you trick questions. "So you were just a little sore after the accident? Did you see the other car at all before impact?" Every word you say is being analyzed for weakness. Giving a recorded statement without your lawyer is like walking into a police interrogation without a lawyer. You have everything to lose and absolutely nothing to gain. And this doesn't just apply to the insurance company. Don't talk about the details of your case with your friends, your coworkers, your neighbors. You never know who they might talk to. You never know who could be called as a witness down the line. The other side can subpoena people. Your words can get twisted and repeated. Think of it like this. Every word you speak about your case is a potential brick. And the other side is listening, collecting those bricks, and using them to build a wall between you and the compensation you deserve. Your lawyer's office should be the only place you speak freely about your case. It is a sanctuary. Everywhere else is a potential courtroom. These mistakes, social media, downplaying your injuries, and talking too much, are what separate a successful case from a heartbreaking failure. And it brings us to a final bonus question. This one isn't a question you ask the lawyer. It's the question you must ask yourself before you sign that contract. Am I prepared to be the best possible client? Because the truth is, this is a partnership. The greatest trial lawyer in the country can't win if their client is posting pictures on Instagram, telling their doctor they feel fine, and giving recorded statements to the defense. Being a great client means you commit to 3 things. First, radical honesty with your lawyer. Tell them everything, especially the bad stuff. Did you have a prior back injury from college? Tell them. We can deal with bad facts if we know about them. We cannot deal with surprises. Second, patience. The legal system is a glacier. It moves incredibly slowly. Your case could take years. You have to trust the process and your legal team. And third, responsiveness. When your lawyer's office calls or emails, you respond quickly. They need documents, you get them the documents. You are an active, engaged partner in your own rescue. So let's bring it all home. The journey to justice after an injury is terrifying. Choosing the person to guide you is one of the most important decisions you will ever make. It's not about finding the guy with the flashiest billboard. It's about finding a specialist, a communicator, an experienced veteran, a strategist, and a partner. It's about asking the right questions. What percentage of your practice is dedicated to cases like mine? Who, specifically, will be my day-to-day contact? Have you taken a case like mine to trial, and what happened? Can you walk me through your firm's process? And what do you expect from me? Asking these questions transforms you from a victim into an informed consumer. And then, looking in the mirror and committing to being the best possible client transforms you into a partner. Hiring a personal injury lawyer isn't about handing your problem off to someone else. It's about hiring a guide to walk with you through the fire. And with the right guide and the right preparation from you, you will make it to the other side. Don't just find a lawyer. Find your partner. Your future depends on it.